what happened in Bryan Kohberger's status hearing today, and what insights can we get about both the defense and the prosecution strategies. Fuel me once here, driving instructor of the world. Now, a status hearing is just a scheduling hearing, at least for today. We've got a brand new judge. He just wanted to get everyone up to speed on his expectations and sort of get the information that he needed to establish when the trial would start. Now, Judge had given a June 2nd start date, but Judge Steven Hippler, pictured there at the bottom, wanted to sort of feel out the defense and prosecution because he wanted to move the trial up to May. Let's talk about this. He started by saying, "I'd like to tell you I'm happy to be here, but why start with an untruth? I'm accepting of my responsibility to be here." Now, he gave then some expectations. He comes off as a very no-nonsense, very sort of careful, maybe even measured judge. His first expectation is when you file motions, etc., you have to include Word documents by email. Then he took up the idea of Bryan Kohberger being allowed to wear civilian clothes. He issued an order yesterday to allow Bryan Kohberger to wear the suit or civilian clothes. But he said that they're going to have a hearing without Bryan Kohberger there to talk about his rights versus security. Now, when they're talking about his rights, they're talking about his right to appear innocent. He's innocent before proven guilty. If he comes out decked in jail garb, he's going to be perceived more by the jury as guilty. Whether it's true or not, whether they're instructed to disregard it or not, Ann Taylor's going to argue, and it's her right to argue, that he needs to appear innocent as his status is innocent until proven guilty, which that's what the trial's there for. The judge ordered this to be a closed hearing, so it's going to be a close hearing. He also said he expects everyone to get along. He understands that they're the highest stakes here, but they need to keep the oaths that they've made, remain civil, no personal or ad hominem attacks. Ad hominem attacks, name calling. Personal attacks are not dealing with the evidence, but dealing with the actual lawyers or, presenting each side. He said that's the first and only lecture for the remainder of this case. We'll see if that's true. He did also say when filing motions and you're using case evidence, in other words, evidence that's come from previous court decisions, if there are contradictory precedents in the briefs you're reading, when citing cases, those contradictory precedents need to be included. In other words, let's say there's a contrary opinion from a judge. Supreme Court does this all the time. You'll get a majority opinion and a minority opinion. Or in the case citation, there'll be, hey, here's some precedents where this may not apply, or this was in other courts not seen to be applicable. They need to include those. He wants to be complete. He said the gag order's still in place, and he is definitely not fooling around. He will tolerate no violations. Now, on the June 2nd date, he proposed either May or September to start the trial. And of course, the state wanted May and the defense wanted September. Defenses usually have two strategies. Either speedy trial, get everything rushed so a prosecution doesn't have the time to prepare, or postpone. It's one of the defense's best friends. Why? It removes the emotional connections sometimes, or at least lessens the emotional connections between the incident and the trial for that incident. I don't think that's going to be true in this case, but you can see that Ann Taylor is trying to stall at every chance she gets. We're going to see it in just a minute, too. She cited 3 issues that she's got to deal with. She said, hey, there's a vast amount of discovery. We got 398 gigabytes of new information since August 13th. That turns out not to be true. What they got was what the state had to file as their discovery. In other words, here's all the evidence we're going to draw from. That's what that 398 gigabyte hard drive or, jump drive contained, and says they haven't really even looked at it yet. That's a little hard to believe. She also said they had an expert who passed away, and while they've hired someone new, that expert is not up to speed yet. When the judge probed, it turns out it's a mitigation expert, not an evidence expert. The difference is the evidence expert comes in the main part of the trial. A mitigation expert comes only during the sentencing phase. So if Bryan is found guilty, they'll go to a sentencing phase. In other words, what do you recommend to be the sentence? The state said they only need a week for that. The defense said we need 2 weeks for that. And this witness would be a part of those 2 weeks. The judge just kept saying, the deadline's March for that, and March is a long time away. He said there's 24 hours in a day, and if you use them right, you can get it done. However, he offered to have an ex parte hearing, and it turns out to be right after this trial, about the expert. Ex parte means one party. So only one party, in this case the defense, would appear before the judge and argue that they need this. And the reason for that is they're presenting a witness who would give away some of their strategy, and it's too early for them to have that filed. So we'll see what the judge rules. He could actually rule today or tomorrow based on what he's heard from about Ann's witness. Now, Ann Taylor asked about some funding stuff. Starting October 1st, Idaho changes the way, and this has been in the works for a long time, changes the way that public defenders and their experts and investigators are funded. It will come out of one separate put aside money by the legislature instead of going back and asking for this witness needs to be funded. It's from a 12.2 court law. Ann was worried how she was going to get paid and how her witness is going to pay. Judge said it won't be a problem. Now, the reason why the judge wanted to move the trial is he's worried about the jury, he said. If you take June 2nd to August 31st, that's not only the whole summer for summer vacations, but also in Idaho, school starts mid-August, so that parent's not going to be there for the start of their child's school year. Now, the next deadline is next month. That is on the motions that each side is going to file because the defense is filing a motion to dismiss the DP. The hearing for that will be November 7th. That's the next time we'll, right now, as of now, see Bryan Kohberger in court. The judge also said that he's much more likely to hear things in a timely manner more quickly than Judge John Judge did 14 days after filing the motion. That's actually typical in a court. He also said if someone is arguing a motion, they should be there in court. Anyone else on the team can log in remotely and watch, but those arguing the motion need to be in court. In this ex parte hearing today, Ann Taylor's going to present 2 or 3 reasons, including the expert witness, why they need the September deadline, and we'll see if the judge buys that or not. He repeated at least 3 times, March is a long way away. In other words, March is the deadline for the witness list and discovery from the defense. We'll see what happens, and we'll report it here on The Road of Life. Please drive kind. Thank you.